Hi everyone, Dexter here. Today we're going to talk about Mediation Fund. Recently, the Office of the Court Administrator issued OCA Circular No. 130-2021 pursuant to NBank Resolution dated October 5, 2021, which the court approved the recommendation of PhilJA Chancellor Arturo Di Breon to transfer the handling of Mediation Fund to the Financial Management Office of the Court Administrator. And as a result, a new land bank account for the Mediation Fund was opened and to be used effective November 2, 2021. So all transactions pertaining to the Mediation Fund should be remitted to this new bank account. Okay, and the existing account shall be closed after reconciliation of each transactions. Okay, so before we proceed to the discussion or pertinent provisions about Mediation Fund, you may consider hitting the like button first. So Mediation Fund. The new account name of the Mediation Fund is SC-OCA Mediation Fund. So when Mediation Fund was created in 2004, under Section 9 of Rule 141 of the Revised Rules of Court, so dated August 16, 2004, to be exact. So Section 9 provides that a mediation fee should be collected upon filing of a complaint. So complaint, all civil cases, regardless whether it is mediatable or not, a mediation fee should be collected. Okay? Or an answer with a mediatable permissive counterclaim. So for answers, only mediatable cases. So answer with a mediatable compulsory counterclaim is stricken out. So compulsory counterclaim, no mediation fee. So the fee for compulsory counterclaim is still suspended. Okay, no mediation fee or any legal fee should be collected for filing a compulsory counterclaim. Okay. Or cross-claim, complaint and intervention, third-party complaint, four-party complaint, etc. in civil cases. So all civil cases filed in court should be collected with a mediation fee, except so for small claims cases, there is an NBank resolution, so exempting the small claims cases from the collection of mediation fee. Okay, so a petition, an opposition, and a creditor's claim in special proceedings. So all special proceedings, regardless if it's mediatable or not, mediation fee should be collected. Okay. As a result, a number of litigants or parties complained about the collection of mediation fee. So they were asking the court why they should pay a mediation fee when in fact their cases are not mediatable. And the OCA answered that. So the OCA issued OCA Circular No. 37-2005, dated April 6, 2005. The OCA explained that mediation fee is akin to the UP Legal Research Fee or LRF, meaning if there's an LRF, there should be a mediation fee. Okay, so for the purpose of funding the creation or establishing the Philippine Mediation Center units, okay, that's the purpose of the Mediation Fund. Okay, so another cases, so upon filing of a complaint, information for offenses covered by the Katarungan Pambarangay Law, violation of BP bilang 22, estafa, and libel cases where damages are sought. So mediation fee should be collected for these cases. And third, upon filing of a complaint or information for quasi-offenses under Title 14 of the Revised Penal Code, mediation fee should be collected from these cases. Okay. So OCA Circular No. 37/2005 was issued also to reiterate the collection of mediation fee. So during those days, a number of lower courts were not collecting mediation fee properly. So they thought that there was no Philippine Mediation Center on their area. They're not required to collect mediation fee. So they were wrong. So OCA informed them that they should collect mediation fee even there was no Philippine Mediation Center on the area. Okay. So another reiteration made by this OCA Circular 37, 2005. So pauper litigants are exempt from contributing to the mediation fund, provided that the unpaid contribution shall be considered a lien on any monetary award in a judgment favorable to the pauper litigant. So just the same dun the legal fees. If the pauper litigants receive monetary award upon the termination of the case, so they should pay the mediation fee and the legal fees. Okay? So an accused appellant is also exempt from contributing to the mediation fund. Okay, so if the accused appeals, no mediation fee should be collected. But appeal fee, the accused is required to pay an appeal fee. So no mediation appeal fee, but there's a filing fee for filing a notice of appeal. So the purpose of mediation fund under OCA Circular 37, 2005 also, the purpose of the mediation fund, the fund shall be utilized for the promotion of court-annexed mediation and other relevant modes of alternative dispute resolution, ADR, training of mediators, payment of mediators' fees, and operating expenses of the Philippine Mediation Center or the PMC units, including expenses for technical assistance and organizations, individuals, transportation, communication expenses, photocopying, supplies, and equipment expense allowance, and miscellaneous expenses whenever necessary, subject to auditing rules and regulations. Okay? That's the purpose of mediation fund. So the seminars, the training seminars conducted by PILJA for court employees, so the PILJA is getting the funds from the mediation, from this fund. In the resolution dated January 11, 2011, in Administrative Matter Number 11-1-6-SC-PILJA, and as implemented by OCA Circular 51, 2011, April 6, 2011, the Court en banc approved the consolidated and revised guidelines to implement the expanded coverage of court-annexed mediation or CAM and judicial dispute resolution or JDR, and included the following cases subject to collection of mediation fee. So this resolution clarified that intellectual property cases are also subject for the collection of mediation fee. Another, commercial or corporate cases, so it should be collected with mediation fee also. And third, the environmental cases, also subject for the collection of mediation fee. So the following civil cases shall not be referred to mediation. So, civil cases which by law cannot be compromised, that is Article 2035 of the new Civil Code. So what is that article? So Article 2035 provides that no compromise upon the following questions shall be valid. First, the civil status of persons. Second, the validity of a marriage or illegal separation. Third, any ground for legal separation. Fourth, future support. Fifth, the jurisdiction of courts. Sixth, future legitime. Okay, so validity of marriage or nullification of marriage, legal separation, it's not mediatable, but the court is requiring the party to pay a mediation fee. So mediation fee is required. Even it's not mediatable, the court should collect a mediation fee, but it should not be referred to mediation. Okay. So second, other criminal cases not covered by the Katarungang Pambarangay Law or not falling under quasi-offenses under Title 14 of the Revised Penal Code. Felonies punishable by correctional penalties not exceeding 6 years imprisonment. Estafa, theft, and libel. Okay, third, habeas corpus petitions. So, fourth, all cases under Republic Act Number 9262, the violence against women and children. Fifth, cases with pending application for restraining orders or preliminary injunctions. So, shall not be referred to mediation. However, in cases covered under number 1, number 4, and number 5, so that these 3, 1, 4, and 5, where the parties inform the court that they have agreed to undergo mediation on some respects thereof. For example, custody of minor children, separation of property, or support pendente lite. So the court shall refer them to mediation. So mediation is allowed if the parties agree. Then before that time, so the OCA issued this circulars to reiterate the collection of mediation fee. So after the 37/2005, many courts still didn't collect the mediation fee. So that's why OCA Circular 58/2007 was issued, followed by 158/2010, then 51/2011, 14/2012, then 44/2012. So all these circulars reiterated the collection of mediation fee. And we go to criminal cases. So OCA Circular number 101/2017 was issued pursuant to Administrative Matter number 15-06-10-SC dated of April 25, 2017. That is the implementation of the continuous trial in criminal cases. So it provides that a mandatory coverage for mediation in criminal cases. So these cases, first one, category of crimes where payment may prevent criminal prosecution or may extinguish criminal liability, such as violations of bouncing checks law or BP bilang 22. Second, Social Security Law or Republic Act 1161 as amended by RA 8282. And Pag-ibig Fund Law of 2009 or Republic Act number 9679. So the violations of this law subject to mediation. Okay. Second category, so crimes against property under Title 10 of the Revised Penal Code where the obligation may be civil in nature, such as, unang-una, first one, theft under Article 308 of the Revised Penal Code, cognizable by the first level courts. Second, estafa under Article 315, Paragraph 1 of the Revised Penal Code. So, except estafa under Article 315, Paragraph 2 and 3. So, Paragraph 2 and 3, 315 are not subject to mediation. Third, what other forms of swindling under Article 316 of the Revised Penal Code. Fourth, swindling a minor under Article 317 of the Revised Penal Code. Fifth, other deceits under Article 318 of the Revised Penal Code. And sixth, malicious mischief under Article 327 of the Revised Penal Code. Third category, crimes against honor under Title 13 of the Revised Penal Code where the liability may be civil in nature, such as libel by means of writings or similar means under Article 355 of the Revised Penal Code. Second, threatening to publish and offer to present such publication for a compensation under Article 356 of the Revised Penal Code. Third, prohibited publication of acts referred to in the course of official proceedings under Article 357 of the Revised Penal Code. Fourth, grave slander or grave oral defamation of serious and insulting nature under Article 358 of the Revised Penal Code. Fifth, simple slander or oral defamation, not of a serious and insulting nature under Article 358, Paragraph 2 of the Revised Penal Code. 6. Grave slander by deed of a serious nature under Article 359, Paragraph 1 of the Revised Penal Code. 7. Simple slander by deed not of a serious nature under Article 359, Paragraph 1 of the Revised Penal Code. 8. Incriminating innocent person under Article 363 of the Revised Penal Code. And last, 9th, intriguing against honor under Article 364 of the Revised Penal Code. Fourth category, libel under the Cybercrime Prevention Act of 2012 or Republic Act number 10175. The fifth, criminal negligence under Title 14 of the Revised Penal Code, where the liability may be civil in nature. And the last one, intellectual property rights cases, where the liability may be civil in nature. So these criminal cases, a collection of mediation fee is required if these cases are filed. So how much mediation fee? So upon filing, 500 pesos per case. So OCA Circular number 60 2006 clarified for BP 22 cases. Even if it's filed multiple BP 22 cases, the mediation fee should be collected per count, so per check or per case. Okay. Same with the Destapa cases, so clarified under OCA Circular number 65-2007. So if multiple cases of Destapa, the mediation fee should be collected per case. So appeal fee for mediation fund from first level to second level courts, it's 500 pesos. Okay, second level courts to the appellate courts, the Court of Appeals, Court of Tax Appeals, and SC, 1,000 pesos. To note, I repeat, accused appellant is exempted from payment of mediation appeal fee. So it's provided under Section 9 of the Rule 141, Revised Rules of Court. So this is the new circular which I mentioned earlier. So the OCA, Office of the Court Administrator, issued. So there is a new mediation fund account to deposit some mediation fees to the new mediation fund account. So effective November 2, 2021. So this circular, pursuant to Administrative Number 21-08-01, the SC PILJA, dated October 5, 2021, approved so first, the transfer of the Philippine Mediation Center office from the PILJA to the OCA. So this office will be converted to a division. So Philippine Mediation Center Division, now part of the Court Management Office, OCA. So it's not anymore under the PILJA. Okay. Second, approve the administration by the Financial Management Office or FMO of the OCA. So the monthly reports for the mediation fund shall now be submitted to the accounting division of the Financial Management Office of OCA or the FMO. So same thing with the JDF, SAJ, GF reports. Those reports now should be submitted to accounting division of the Financial Management Office. So no reports shall be submitted to PILJA. So the mediation fund should be submitted to the accounting division of the Financial Management Office. Okay. So the third, the new SC OCA Mediation Fund account. So it's number 3472-1010-47. So that is the new account of the Mediation Fund, effective November 2, 2021. And the fourth one, the submission of financial reports of MF to the accounting division, FMO. So 2 and 4 are related. Okay. So remember again, the new account shall be effective November 2, 2021. So all collections must be deposited to this account, to the new account, effective November 2, 2021. Okay, don't forget that. So if you fail to remit on this account, the new account, it's an audit observation. You will become required to explain for not following this OCA Circular number 130/2021. Okay. Alright, if you want to see more videos like this one, you may consider subscribing, and you can share this video to anyone. Be sure to hit the like button. Thank you. Stay safe, everyone. Bye.